Hi there, and welcome back to learning the Arkansas Real Estate Commission Regulations sections 8 and 10. In my first video, we did section 8, and now we're going to do 10 and reading from our quick reference guide. You should be able to just listen to this so that you can know the laws. Okay, section 10 is broker responsibilities, ethical requirements, trust funds and accounts, listing and offer and acceptance agreements, and criminal convictions. Here we go. Ready? Section 10.1, dealing independently of a principal broker. If a principal broker or executive broker learns a salesperson, associate broker, or executive broker licensed under such principal broker or executive broker has, without permission of the principal broker or executive broker, engaged in a real estate activity independently or through some other broker, it is the duty of the principal broker or executive broker to immediately notify the commission in writing and forward such licensee's license to the commission. B. Any salesperson, associate broker, or executive broker who engages in real estate activities independently or through some other broker without permission from the principal broker or executive broker shall be presumed to be in violation of A.C.A. 17 to 42.311. That's a section. And subject to appropriate sanctions. So there you go. Don't operate without dealing with your principal broker or you're in trouble, okay? Or you can be in trouble. 10.2, expiration date for agency agreements and contracts. A licensee shall put a specific determinable duration or a specific expiration date on all written agency agreements or contracts or an extensions thereof. Examples: listing and buyer representation agreements or contracts. 10.3, membership in trade organizations. A licensee shall not use terms such as realtor, realtist, or any other trade name or insignia of membership of any real estate organization of which the licensee is not a member. Ooh, big boy stuff. Okay, 10.4, broker responsibilities, executive brokers, and part-time brokers. A1, a principal broker is generally responsible for all business conducted by the broker's firm and for all of the real estate activities of all those licensed under or associated with the principal broker, unless the licensee conducted real estate business independently and without permission or authority from the principal broker. If the principal broker learns that a licensee is conducting business independently, that principal broker must comply with Commission Regulation 10.1, which is back to the 10.1 of saying you are not allowed to do that. Okay, so 2, a principal broker may delegate supervisory responsibility to another broker by designating such broker as an executive broker. The executive broker may sign offer and acceptance forms as supervising broker and can be responsible for instructing and supervising salespersons and or brokers for whom the executive broker is responsible. The executive broker may also be delegated responsibility by the principal broker for administrative procedures required by the commission, such as signing transfer applications. For each executive broker so designated, the principal broker must complete and file with the commission an appropriate designation form signed by both the principal broker and the designated executive broker. The designation of the executive broker is effective when filed with the commission. 3, designation of one or more executive brokers does not absolve the principal broker of general responsibility for the conduct of all real estate business conducted by the principal broker's firm, and the principal broker is specifically responsible for the activities of all the executive brokers. Principal brokers and executive brokers have the duty and responsibility to instruct those brokers and salespersons licensed under them with regard to the fundamentals of real estate practice and the ethics of the profession, and to keep them informed and abreast of all changes and developments pertaining to the real estate license law and commission's regulations. They also shall exercise strict supervision of the real estate activities of all those licensed under them and for whom they have supervisory responsibility. Whether or not a principal broker or executive broker has discharged these responsibilities for those licensed under him or her will depend on various factors and circumstances, including without limitation the following. 1. Frequency and manner of contact and communication. 2. Type and frequency of educational and instructional activities. 3. Method and frequency of monitoring real estate activities. Okay, that's it. D1. The preparation of instruments in connection with a real estate rental or sale and the closing of a sale by licensee must be performed by or under the specific supervision of the principal broker. If the principal broker or designated executive broker or their assigned licensee closes a transaction or selects a third party to close the transaction, it is the responsibility of the principal broker or designated executive broker to ensure that the real estate closing conducted on behalf of the principal broker's or designated executive broker's client is conducted in accordance with the agreement of the buyer and the seller. If the buyer and or seller selects a third party to close the transaction, the principal broker or designated executive broker or their assigned licensee must provide written closing instructions on behalf of their clients to the third reasonably available to ensure that the closing is conducted in accordance with the agreement of their client. It is strongly recommended that the principal broker, designated executive broker, or assigned licensee advise the client to contract the closing agent or title insurer about the availability of closing protection. E. No broker who is gainfully employed or who is engaged in a non-real estate related field may employ any licensee to work under the broker's license issued to such broker. A broker who is employed or who is engaged in any field other than real estate will be presumed to be gainfully employed or engaged in a non-real estate related field. This presumption may be overcome by proof that such employment or engagement is in a real estate related field, and 2, conducted in the same office as the broker's real estate business. Okay. We're going to go on into advertising. So we understand that the broker has some big time responsibilities, and if those responsibilities are changed and different brokers are handling it, then all of that has to be in writing and okay with the client. All right, this is my favorite, advertising. 10.5A. Licensee may not advertise any property, including the licensee's own property, for sale or rent, or display a real estate sign without including in that advertisement or sign the name of the firm with whom that licensee is licensed. It has to include the name of the firm. Okay? B. A principal broker and any persons licensed with said principal broker shall not advertise or otherwise conduct real estate brokerage business under any name other than the name in which the principal's broker license has been issued. Got it? C. In public advertising, a principal broker shall be especially careful to present a true picture and should not permit licensees to use individual names or telephone numbers unless the licensee's connection with the broker is obvious in the advertisement. Got it? Okay, moving on. 10.6, this is knowledge of property. A licensee shall exert reasonable efforts to ascertain those facts which are material to the value or desirability of every property for which the licensee accepts the agency, so that in offering the property, the licensee will be informed about its condition and thus able to avoid intentional or negligent misrepresentation to the public concerning such property. Okay, that's going to conclude this video. We covered 10.1 through 10.6. Thank you.